What is New Jersey 2C 3914 Unlawful Training in the Use of a Firearm? New Jersey enforces some of the strictest gun laws in the country. Among them is N.J.S.A 2C 3914, a law that targets individuals who teach or participate in firearm training with criminal intent. Unlike charges based on the use or possession of a weapon, this statute punishes the preparation for future unlawful acts, even before a crime occurs. Understanding how this law works is critical, especially for lawful gun owners or anyone involved in firearms instruction. Law and Legal Consequences. N.J.S.A. 2C 3914 makes it a second-degree crime to instruct or train someone in the use or construction of firearms, explosives, or other dangerous devices if that training is intended to further criminal activity. The law also criminalizes group training or drilling when the purpose is preparation for unlawful conduct. Even if no violent act has taken place, providing training for illegal use is enough to bring charges. Violations are prosecuted aggressively. As a second-degree offense, the penalties include 5 to 10 years in prison, up to $150,000 in fines, and a presumption of incarceration, even for individuals without a prior record. The law falls under the Graves Act, which imposes mandatory minimum sentences and restricts parole eligibility. That means judges have little discretion, and early release options are very limited. Additionally, anyone convicted under this law will face a permanent felony record. This can impact employment, housing, and professional licensing. For non-citizens, a conviction may result in deportation or make them ineligible for immigration relief. WHO can be charged under New Jersey 2C 3914. This law targets very specific conduct. It's not enough to be interested in weapons or to teach someone how to shoot. The law requires that the instruction or training was provided with the intent, or knowledge, that it would be used for a criminal purpose. You could be charged if you knowingly teach someone how to use a gun, build a bomb, or conduct tactical maneuvers when you understand that knowledge will be used in a crime. Similarly, group drills or training events that resemble paramilitary exercises, and are intended to prepare for violence, also fall under this statute. This law is not limited to those who carry out violent acts. Even if you never possessed a weapon yourself, you could be charged if the state believes you helped someone else prepare for a criminal act involving weapons. What counts as training under this law? N.J.S.A. 2C 3914 does not ban lawful firearm instruction. Recreational shooting, martial arts classes, and certified gun safety training are fully legal, provided they're not offered for criminal purposes. The law specifically protects lawful gun ownership and instruction where there's no intent to support illegal behavior. To be found guilty, the prosecution must show that training occurred and that it was intended to prepare someone to commit a crime. Simply being present where firearms are discussed or shown is not enough. The prosecution needs to prove actual participation or instruction, paired with criminal intent. Legal defenses to consider. A key component of this statute is intent. An experienced attorney may be able to challenge the case by questioning whether the defendant truly intended for the training to be used unlawfully. For example, someone running a survival course or self-defense class may have no idea that one participant plans to commit a crime. Another strategy focuses on whether what occurred qualifies as actual training. Just being at a camp or shooting range with others does not mean criminal instruction took place. If the conduct doesn't meet the legal definition of instruction or training for criminal use, the law doesn't apply. Some defenses have involved constitutional challenges, arguing that the law infringes on free speech or assembly. While courts typically uphold the statute, a skilled lawyer can argue that the conduct involved was protected, especially if it was theoretical discussion or lawful demonstration with no criminal intent. Entrapment may also apply in cases where law enforcement pushed a person to participate in training they wouldn't have done otherwise. If undercover officers suggested or encouraged criminal instruction, the defense could argue misconduct. Negotiation is another route. If the state's evidence is weak, a defense attorney may be able to reduce the charge or seek diversion options like pretrial intervention, particularly when no actual crime occurred or the defendant has no prior record. Because of the mandatory sentencing and lifelong impact of a conviction under N.J.S.A 2C 3914, it's critical to get help as soon as possible. The attorneys at Lustberg Law Offices, LLC, have extensive experience handling gun-related charges in New Jersey. We understand the complexity of firearm laws and how to defend against allegations involving unlawful training. Call Lustberg Law Offices, LLC today at 201-880-5311 or visit us at 1 University Plaza Drive, number 212, Hackensack, New Jersey, 07601, United States. Protect your rights and your future with a skilled defense team on your side.